I know my rights. I've committed no crime. You can't keep me here.
I know my rights, and I have nothing to say.
You can't scare me into talking. I know my rights.
I know my rights. I'm in journalism.
I know my rights.
I know my rights.
Look, I know my rights.
I know my rights.
I know my rights.
I know my rights, dirtbag.
You sure about that? You sure about that?
Since the original series launched in 1990, the Law & Order franchise has racked up 6 spin-off series for a whopping total of 62 seasons of television and 1,316 episodes so far. In January, the Special Victims Unit will return for a mind-boggling 25th season, Organized Crime will notch its 4th season, and the original series, after having been revived in 2021, will be tallying its 23rd season. Law & Order is so ubiquitous that at any point during the day, you're likely to find a rerun while you're flipping through the channels. Well, I mean, if you had a cable subscription. The people who have those are generally the same ones who own a house they bought for a handjob and a bushel of boysenberries back in the 70s. My point is, Law & Order is an American institution. Right up there with football, unaffordable healthcare, and our penchant for invading Middle Eastern countries for oil. For many viewers, Law & Order is their primary contact point with the criminal legal system, and the show isn't exactly honest or unbiased when it comes to its representation. I don't think it should be controversial to say that Law & Order is a TV show whose express purpose is to honor and celebrate the police.
You know, there is a shared interest in putting bad guys away and having cops, shown in a decent light. I am kind of unabashedly pro law enforcement.
My God, he admitted!
Last year, some British nerd named Oliver took aim at the show and its Copaganda, in an episode that I think 90% of this video's audience has already seen. Johnny O did a great job of breaking down how the show was specifically made to promote the NYPD by creator Dick Wolf, and the way it whitewashes police brutality. So why am I talking about it today? Especially when I've already thanked John Oliver for tackling such a large franchise so that I didn't have to. While Law & Order has come under a decent amount of scrutiny since 2020 for its police promotion, I think that we're still glossing over one of the most insidious aspects of the franchise. Quick trivia question. In the Law & Order universe, which cop has gotten the most bad guys off the street? Is it Olivia Benson, Elliot Stabler, Ray Curtis, whatever Ice-T's character is named? It's none of the above. It's the prosecutor, Jack McCoy. We often focus on Copaganda as it pertains to the police, but as Law & Order is so nice to remind us,
in the criminal justice system, the people are represented by 2 separate yet equally important groups: the police who investigate crime and the district attorneys who prosecute the offenders. These are their stories. Throughout the course of Law & Order, McCoy has been found in contempt of court over 80 times. He's argued passionately for the death penalty while admitting that innocent people will die.
What if someone falls through? How do we rationalize that?
First of all, there's the trial. And then there's a sentencing hearing. And appeals, and more appeals after that. Checks and balances. It's unlikely.
Unlikely?
And has also bragged about how he can send innocent people to prison.
Tell them your staff is so good they can even convict an innocent man.
He also loves to just blurt out inflammatory accusations that are immediately objected to, and that he immediately withdraws. But not before the entire jury hears it.
Your grief might be a little more convincing, sir, if you hadn't just admitted you cut off your wife's head. Objection! Withdrawn.
And McCoy does all of this while routinely withholding evidence and upholding violations of civil liberties.
But some DA told one of his victims those are all civil matters.
Individually, yes, but put them together, you've got a scheme to defraud.
He probably jaywalked a couple of times, too.
Pick him up.
For a low-grade felony?
Either we play it this way, gentlemen, or we don't play it at all.
And he's not alone. Members of the district attorney's office have an outspoken contempt for the very concept of criminal defense lawyers, and a real palpable thirst for blood.
Your client belongs in a pine box, but I will settle for an 8x10 cell where he can rot until he dies.
It's interesting to me that while Americans have grown increasingly more skeptical of the police, the buck seems to stop there. Don't get me wrong, we could always spend more time talking about the police, but we're also missing a huge part of the equation this way. You see, when a police officer harasses you, or arrests you, or beats you, that's just the beginning, because then they hand you over to the real piggies, the ones who wear suits. Welcome to Copaganda, a series of videos exploring the portrayal of the police on television and how that portrayal has shaped our understanding of who the police are and what they should be. We've covered shows from across the spectrum, from The Wire and We Own the City to Marvel's superhero cops. There's a playlist around here somewhere. I'm not going to list off all the episodes because there are too many. Turns out, there are a lot of cop shows. So far in this series, we focus primarily on the actions of police departments and the way TV shows about them promote the status quo of policing. But today, we're going to turn our attention to the lawyers who back them up.
Guilty and the death penalty. You know, I thought he was gonna walk. Anybody want to go out for a drink?
Like Law & Order, this episode of Copaganda will be split into two separate yet equally important videos. In the first, we'll be talking about the structure that backs up cops and how Law & Order sells the unjust system to its audience. In the second video, we will also be talking about that, just more. Because as it turns out, cops, prosecutors, and courts, not really all that separate at all. We have this idea that justice is blind, that the legal system is some indifferent force of nature. Yeah, being harassed by the police is bad, but if you didn't do anything wrong, you should probably be fine, right? This is America, and in America, we have this little thing called the Constitution. Ever heard of it? And freedom of speech. We got the guns and right to remain silent. I know my rights. And that would be a reasonable thing to think if you watch Law & Order. What with the way it walks us through legal procedure.
And refer you to Michigan versus Duran and Gerstein versus Pugh.
The Supreme Court reversed Duran.
Once the governor of the demanding state signs the extradition papers, they're valid on their face. The asylum state can't challenge them.
And under Gerstein, California doesn't have to grant extradition until a neutral court determines probable cause.
That's not what Gerstein says. It says whatever Judge Van Ness interprets it to say.
Your Honor, Ms. Russell has failed to legal, and she's legally legal. We ask the court to legal.
We're not all lawyers. Most of us have no idea what these people are talking about. To most of us, legalese sounds like a foreign language.
Of course, the blah 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 blog. Wow, you, sir, are a mouthful.
So I called up two lawyers to help me parse how our rights work in practice and to talk about the way TV shapes our understanding of them.
So first of all, I wish people were nice enough to ask you why doesn't it work the way it does on TV, because that would mean they would have to realize that it didn't work the way it did on TV, and that's not what happens. It's usually throughout your entire representation, you realize that they are taking advice from the media, or that's what their perception is.
That's Olay Olurin, a former New York City public defender and movement lawyer. We'll be hearing from her throughout this two-part episode, and we'll also be hearing from former public defender and current host of the 5-4 podcast, Rhiannon Hamam, to understand the big picture of how these rights are legally defined.
The way that the Supreme Court has created all these rules that in effect, the result is that we just rubber stamp convictions.
Oh yeah, we're not just pointing to prosecutors as cops, we're going all the way to the Supreme Court, baby! Brett Kavanaugh, you better put down your 75th natty light of the night. Samuel Alito, you better be shaking in your hooves. And Clarence Thomas, you better wrap up hunting children for sport on Billionaire Island. I'm coming for all you fuckers.
We drank beer, my friends and I, the boys and girls. Yes, we drank beer. I liked beer. Still like beer.
Law & Order massively distorts how criminal rights are exercised and protected in real life, and it does so in a very intentional way, one that pays lip service to them while also minimizing their importance in order to whitewash the very real ways those rights are being ignored and eroded.
What do you suggest? That we find some guy in Milwaukee with body parts in his freezer and let him walk because some cop got too rough with him?
While Law & Order is just a TV show, it is perhaps the most prolific pop culture presentation of the justice system in American culture. And as the lawyers Michael Asimov and Shannon Mader wrote in their book Law and Popular Culture, quote, most people learn most of what they think they know about the law and lawyers from consuming popular legal culture.
Like they want their legally blonde moment where she's like, ah, shit, yes, I did do it. I permed my hair. Damn it, you got me. I killed him. Like, no.
Clients will say things like, well, I object to that. Right? Or like, right, like using this language and vocabulary that they've clearly learned from TV and media about the legal system.
If you aren't part of an over-policed population, Law & Order might be your main source of legal advice, and that is a major problem. So what does Law & Order show us about the criminal legal system? How does that differ from reality? And what does that distinction mean? Before we get into it, a few quick disclaimers. This is not going to be a lawyer reacts video. There's nothing wrong with those videos, but I'm not a lawyer. Also, those tend to focus more on what Law & Order gets wrong about procedure, rather than why it's written that way and what kind of impression it leaves its audience with, which is what I'll be focusing on. Second, I'm going to be focusing most intensely on the original Law & Order. It has the most iconic lawyer from the franchise, it's been revived, and everything else in the franchise flows from the success of that series. Alright, let's do the Law & Order episode. To understand Law & Order, there are two dicks that we really need to learn about first. Dick Wolf and Dick Nixon. See, you didn't think I was going anywhere with that, but boy, do you look silly now. Law & Order is one of those American things that has been around so long that most people don't even really know where or how it started. Like apple pie, or shitty light beer, or gun violence. You may have also noticed that Law & Order isn't just the title of this TV franchise, it's something that politicians routinely campaign on.
We will have law and order on the streets of this country.
Are you in favor of law and order?
I'm in favor of law. You follow it.
Are you in favor of law and order? Go
yes,
ahead.
I'm a, you asked a question, let him finish. Law and order. Law and order. Let him law and order with justice.
Notably, in 2020, then President Donald Trump responded to the Black Lives Matter protests around the globe with a tweet saying, "Law and order." I don't have a good Trump impression, so I just tried to embody the all caps. SVU actor Chris Maloney responded with, "You would be arrested," which is really funny when you dive into the history of that phrase, which we are going to do now. Let's set the scene. Cue the mood lighting. I'm not going to change the lighting. It's too hard. It's the 1960s. The nightly news is flooded with images of Americans dying in Vietnam and hippies protesting the war at home. The civil rights movement is also in full swing, and frustration over the slow march of progress has reached a boiling point. In 1967, riots and protests break out in over 150 cities across the country, prompting the Miami police chief to utter the now infamous words, "When the looting starts, the shooting starts." You know, some things just never change. While the Kerner Commission, a very detailed federal report ordered by President Johnson, reported that those riots were brought on mainly by inequalities,
the Kerner Commission's conclusions were stark. It pointed to decades of pent-up frustration in Black communities over police brutality, poverty, and the inequality caused by discrimination and segregation. And the commission placed the blame for those inequalities squarely on white Americans and racism.
Majority of white people said, "Nah, it doesn't feel right to me. We passed the Voting Rights Act like 2 years ago, so surely inequality has been defeated in the marketplace of ideas." Things don't get much better the next year in 1968, when Martin Luther King Jr. is assassinated, prompting even more civil unrest. It's also an election year. Failed presidential candidate Richard Nixon really wants to be president, you see, and he sees an opportunity. Running against famed Southern segregationist George Wallace, a man most famous for saying,
"And I say segregation now, segregation tomorrow, and segregation forever."
Nixon figures out a way to tap into that energy without being labeled quite so racist. In 1967, he responds to the unrest in a Reader's Digest op-ed. "There is a permissiveness toward violation of the law and public order by those who agree with the cause in question." This term, law and order, was chosen specifically as a racist dog whistle. As historian Josh Zeitz described it in 2016, as president, Nixon focused intensely on law and order themes, subtly tapping into the fears of white Southerners as well as many white working-class Northerners, who associated the rise in crime with urban riots specifically and African Americans more generally. Nixon recognized this connection when he privately reviewed one of his campaign's hard-hitting television ads in 1972 about urban crime and remarked, "This hits it right on the nose. It's all about law and order and the damn Puerto Rican groups out there."
It is time for an honest look at the problem of order in the United States. Dissent is a necessary ingredient of change. But in a system of government that provides for peaceful change, there is no cause that justifies resort to violence.
No cause to resort to violence, says the man who killed millions of Cambodians for simply being in the country next to Vietnam. Give me a fucking break. But this isn't something that we only know today, after Nixon's fetish for recording all his racial slurs went public. His law and order rhetoric was aimed squarely at the civil rights gains of the Supreme Court under Chief Justice Earl Warren, from desegregating schools to creating Miranda rights to upholding the right to interracial marriage. And he said this pretty explicitly. Nixon wrote in that same op-ed that our judges and courts must take a large measure of responsibility for the current lawlessness. I like doing that one. I like saying lawlessness with the Nixon accent. You can hear the jowls. Lawlessness. The Warren Court is largely where our modern conception of the Supreme Court comes from, as a protector of rights and liberties.
Most people's understanding of the Supreme Court is that, like, it does good things because they decided Brown v. Board, right? And then it doesn't go really beyond that. But actually, when you like dig into Supreme Court cases and jurisprudence and the development of the law at the Supreme Court since the Warren Court, right? Like since the mid 60s to early 70s, after that period, you see a Supreme Court that's really on a mission to really undo a lot of what the Warren Court did.
Nixon is generally considered to be a pioneer of the modern conservative movement, as he kicked off a span from 1969 to 1993 of nearly uninterrupted Republican presidents. But despite presidents like Nixon and Reagan promising to be tough on crime, the American violent crime rate soared during their terms. Weird how that works out. You may have heard that crime is on a historic downtrend in America, which is very true, but that's partially because in the late 80s and early 90s, it was super high. Fun fact, there are a lot of theories as to why this spike in crime happened, why it peaked so hard and fell so fast. The Brennan Institute studied it and came up with a ton of possible reasons, almost all of which were inconclusive, except lead exposure. If you map lead exposure onto the violent crime rate, it's almost too perfect to be a coincidence. Turns out that the EPA might be better at fighting violent crime than any police department, and we should be funding them more and police departments less. You know, if we care about violent crime. Anyways, my point is that in 1990, violent crime is at an all-time high, and we don't know about the lead thing yet. So crime was being mostly addressed with a zero-tolerance law and order approach. George Bush had just won the presidency in part by using the same kind of law and order language as a racist dog whistle in the now infamous Willie Horton attack ads.
One was Willie Horton, who murdered a boy in a robbery, stabbing him 19 times. Despite a life sentence, Horton received 10 weekend passes from prison.
And it's out of this environment that Dick Wolf has an idea for a TV show. His idea was to make a police procedural that split its time equally between the officers making arrests and the court trials that followed. TV executives said, yeah, we made that show back in 1963. It's called Arrest and Trial. Maybe you should check it out. Each 90-minute episode of Arrest and Trial would split its time between the cop making the arrest and the defense attorney defending them. It was meant to showcase the adversarial nature of our legal system, to highlight its importance. And the show was low-key kinda woke for the time. The first episode is about a trucker who, while chasing down thieves who had stolen his cargo, accidentally runs a motorcycle cop off the road, killing him.
You hit him, buddy. We saw the whole thing. You killed him!
The prosecutor wants the death penalty for killing a cop, but we are made to sympathize with the defendant's situation.
We've got a whole city full of people to think about. One case can't stop the machinery.
Don't you think I know it? That's been Jared's problem all his life. He was never important enough to stop the machinery.
By the end of the episode, he has successfully pleaded down from the death penalty to involuntary manslaughter.
What can I do? I just believe in giving a sucker a break.
Dick Wolf watched this and he fucking hated it. Couldn't stand it. He described his experience watching the show to Variety in 1993. Quote, sure enough, there was a crime and the cop arrested a guy for armed robbery at the end of the first 45 minutes. Then they went into the court case and Chuck Connors got the guy off. He was the wrong guy. That was a problem. Dick Wolf actually hated Arrest and Trial so much that in 2000 he launched a reality TV version of Law & Order with the same title, trying to rebrand the original into a much more explicitly pro-police show. While the structure of cops and trials is still present in Law & Order, the biggest change Wolf made from Arrest and Trial was to focus on prosecutors instead of defense attorneys. As he stated in the Law & Order official companion book, I believed the heroes weren't the defense attorneys who were getting these scumbags off. The heroes were the prosecutors. Where Arrest and Trial depicted the back and forth adversarial nature of our justice system, Law & Order aligns the audience purely with law enforcement. We see everything from their perspective, and the show is very overt in the way that it tries to eliminate any sympathies you might find for defendants. Some of these techniques come straight from advertising, which is where Dick Wolf got his start, making very sleazy ads.
Would people recognize these commercials?
Oh,
today?
Sure. I'm Cheryl Flyme.
I'm Cheryl Flyme. Hey, today, that's immediate sexual discrimination. That's immediately going to prison.
Enough,
7 years.
Interestingly enough, I think it was at the time one of the most successful airline campaigns ever because it was
I'm Cheryl Flyme.
It was aimed at businessmen, and all the stewardesses were from the University of Florida and were 22 years old. That's why they flew the airline.
I'm surprised that didn't end your career.
What's even more gross is that you can see the same strategy at work all over Law & Order. A 2013 Law and Psychology Review article noted how the application of advertising tropes like beauty is goodness and sex sells supported the show's district's attorney's office. As the author Adam Shitterman writes, quote, half of the assistant district attorneys, including the few who appeared only once or twice across Law & Order, SVU, and LA, were attractive females 30 years old or younger when they began their Law & Order careers. These included professional models like Sharon Stone and literal Bond girls like Carrie Lowell. In fact, most of the actresses playing ADAs were around 26 when they started on the show, and I don't know how you get that job directly out of law school. This isn't because Law & Order is an early precursor to girl boss feminism, though. These young ADAs are matched up with much older men as their superiors, in the forms of Jack McCoy, Adam Schiff, Arthur Branch, and guy who has a kink for serial killers, Will Graham. I mean, actor Hugh Dancy. This kind of hierarchy with powerful men at the top, if only there was a word for that, makes it clear that the female characters exist primarily as eye candy. Sure, they'll bring up liberal perspectives on the law sometimes, but mostly just so they can be put in their place by their higher-ups.
When I said what I did about Roe v. Wade being wrong, what did you think?
That you let your religious beliefs cloud your legal judgment.
The reason I disagree with Roe has nothing to do with going to church on Sunday. That's a bad decision because it's based on a legal fiction, better known as the right to privacy.
Mostly, they're there in the same way that guys hire OnlyFans models to pose with them so that other men think that they must be succeeding in life. And just like so many of those entrepreneurs, you'll probably be unsurprised to find that Dick Wolf has hired showrunners and actors who sexually harass their coworkers on set. So, maybe it's not so much about trying to make prosecution sexy, and more about trying to lure women onto the franchise at a young age so that he can groom them. Is that better? Is that worse? Maybe he's just taken this whole cosplaying as Nixon thing too far. To drive the point home, defense attorneys tend to look more like Mr. Eyebrows over here, or this older woman, or this smartass.
I asked my client a question, he answered it. I didn't hear me use the word justification, did you? Did you?
I mean, it is hot the way he stands up for criminal defendants, but I can't say he would have caught my eye otherwise. Regardless, this glowing portrayal of prosecutors is hardly just a casting decision. Law & Order, like every cop show in existence, juices its stats when it comes to crime and policing. Just pulls down their shorts and injects a big needle of anabolic steroids right into that stat ass. According to the crowdfunded research project Logged and Ordered at overthinkingit.com, the first 20 seasons of Law & Order, a total of 455 episodes, returned a not guilty verdict just 34 times, accounting for 8% of all cases. Charges were dismissed in just 4 episodes, less than half the number of times a defendant was killed during the trial. I know it was an SVU, but shout out to Kyle MacLachlan. But bigger picture, 36% of cases return a guilty verdict, another 34% resolve in a plea bargain, and another 11% are implied wins. And at first look, you might think that the number that's being juiced the most is that guilty not guilty ratio. Surely a trial must be more of a crapshoot, right? After all, they're always talking about how risky a jury is on Law & Order.
I figure it's better than taking a chance with a jury.
In his shoes, I'd take a chance with a jury.
If even one juror believes her outrageous accusations, it could hang the jury.
But in reality, that's one of the more accurate stats. According to data from the Administrative Office of U.S. Courts, a whopping 83% of federal criminal defendants who went to trial were convicted. No, there's a way more egregious statistical distortion here. Just how many people actually go to trial?
Most things never go to trial. Never go to trial. I never go to trial. Never go to trial. People can represent, you or your average public defender can represent thousands of people that never go to trial. The average thing doesn't does not go to trial in the legal system.
According to data from the National Association of Criminal Defense Lawyers, defendants have opted to concede their guilt in over 97% of cases. Just think about that number for a second. The right to a trial is in the Constitution. It's the 6th Amendment, and less than 3% of people exercise that right. If only that were true for the Second Amendment, too. So why are all of these people opting for plea deals instead of hearing their case in court? Well, it's due to something known as the trial penalty. There's something inherently coercive about a plea deal, often baked into the fabric of the law itself. One that promises a more severe sentence if found guilty in court versus just pleading guilty.
In Texas, the 3 strikes rule operates that if you have gone to prison 2 times, on your 3rd time, it doesn't matter what felony you're charged with. If you go to trial, the sentencing scheme is 25 to life. So prosecutors use that in Texas all the time. Oh, your client has been to prison twice before? Okay, well, I'll offer them, if they plead guilty, I'll offer them 20 years. But if we go to trial, that sentencing scheme is going to be 25 to life. So if they're found guilty, the jury could give them life.
The Supreme Court actually used to find plea deals like this objectionable. In cases like United States v. Jackson in 1968, the court found that a statute that allowed for the death penalty only in cases that go to trial imposed an, quote, impermissible burden on the exercise of a constitutional right. Another Warren Court W, baby. The W in Warren stands for win. But almost immediately afterward, the court began backtracking, and by 1973, a mere 5 years later, the majority opinion of the court stated that, quote, although every such circumstance has a discouraging effect on the defendant's assertion of his trial rights, the imposition of these difficult choices was upheld as an inevitable attribute of any legitimate system which tolerates and encourages the negotiation of pleas. In other words, yeah, plea deals are trying to coerce you out of your constitutional right, but without plea deals, how could we possibly put away this many people? Now, there's probably a part of you that says this makes sense, that an offer of a lesser sentence is a good deal for a defendant who might be guilty, that it helps with the efficiency of the system.
There's this argument that people like in theory land where they're like, if we took everything to trial, the system would collapse, because it would, technically speaking, that they couldn't try everybody. But then a whole gaggle of people are going to jail and prison in worse circumstances and all that or whatever. There's a reason why most things are pled out.
First of all, I'd like to point out again that your right to trial is a constitutional right. You should never be punished for exercising that right. Just as a principle. It's kind of the whole point of rights. Second, plea deals aren't some kind of reward. Like, plead guilty and we'll knock your sentence down from 25 years to 20 as a little treat.
I'm charging all 3. First one who folds gets a walk.
It's like playing a high-stakes version of Deal or No Deal.
I think people really lose sight of, why do we have the damn constitutional rights to begin with, right? Okay, look at the Bill of Rights. There's 10 constitutional rights that are broadly protected there. Okay, count how many are about criminal defendants. The 4th is about criminal defendants. The 5th and the 6th are about criminal defendants. The 8th is about criminal defendants. That's fully 40%. If you don't count the First Amendment, which is also very often charging people criminally, right?
On top of that, prosecutors don't just offer a lower sentence if you plead guilty. They actively threaten more severe charges if you exercise the right to trial. As the NACDL explains, quote, guilty pleas have replaced trials for a very simple reason. Individuals who choose to exercise their 6th Amendment right to trial face exponentially higher sentences if they invoke the right to trial and lose. This trial penalty is now so severe and pervasive that it has virtually eliminated the constitutional right to a trial. To avoid the penalty, accused persons must surrender many other fundamental rights which are essential to a fair justice system. Prosecutors have complete discretion when it comes to the charges they want to file, and can threaten to charge defendants under statutes that carry much more severe sentences.
You know this is an attempted murder. You're just bullying the boy.
I'm going ahead with this, counselor. Minimum mercy, maximum sentence.
For example, take the case of David Anthony Taylor, who was a grunt in a string of gang robberies. When he exercised his constitutional right to trial, the prosecutor for his case filed additional superseding indictments, adding 25 years onto Taylor's sentence. After he was found guilty, the prosecutor even pursued the maximum sentence of 42 years, despite the fact that the ringleader of the robberies had been sentenced to just 22 years. This kind of upcharging is not only allowed in our legal system, but actively encouraged.
Sure, it's deal or no deal. If you think very theoretically and you're not thinking about like what materially this is talking about, we're not talking about like a high risk situation where you could make a lot of money, right? Where there's a huge reward. This is not like a risk reward. It's actually like risk incredible harm and violence in your life.
Now, this isn't to say that Law & Order ignores plea deals. They're actually brought up in nearly every single episode. But the show does severely minimize the number of occurrences and goes a long way in normalizing the coercive nature of the practice. Whenever a prosecutor offers a plea deal on Law & Order, it's presented as a lifeline, something that the defendant would be stupid not to take, without ever acknowledging just how warped that decision is.
Look, I get one store owner on that jury, and the best you can hope for is a mistrial.
And you're willing to stake your client's future on that? Mr. Costas, 4 years at Bedford's a whole sight better than 25 to life at Attica.
In fact, McCoy often frames plea deals as letting the defendant off easy.
You didn't have to take the deal clear.
You could have won the case.
We could offer a plea.
No. Castillo needs to go down.
The show has even had the audacity to make it sound like plea bargains are actually a loophole from which people escape justice.
I know you pled over 50 cases last year.
And I figure I saved my clients collectively over 500 years behind bars. Don't let the grandeur fool you, Mr. Robinette. My clients don't drink martinis at the Oak Room. You guys set up the plea bargaining system. Don't blame me for using it.
While nearly every court trial occurs in the same episode as an arrest on Law & Order, that's just not how things work in real life. Defendants might have to wait months or years in pretrial detention before they can ever be heard in court. And even if they're able to make bail, there are tons of consequences from being in touch with the criminal legal system. Good luck getting an apartment or job or any kind of financial assistance if you're facing charges. And remember again who is ending up in this system and facing these plea deals. Primarily poor people and people of color. This is another thing that Law & Order minimizes, overrepresenting both criminals and victims as white, and doing their best to present a race-neutral vision of the criminal legal system. What Law & Order is able to accomplish between this whitewashing of demographic data and minimizing both the occurrence and coercive nature of plea deals is that we assume the guilt of every defendant on the show. Simply being targeted by prosecutors on the show means you're guilty. And this vibe of assumed guilt is the bedrock of the show, one from which everything else flows. In this way, Law & Order endorses and sugarcoats the way in which our legal system actually works, with a presumption of guilt.
If you're there, you did something wrong, the system will work correctly. Sometimes there are these annoying technicalities where somebody gets off, but we know they were guilty, right? But otherwise, judges, prosecutors, cops, for the most part, they're all operating in good faith. We just want to get the bad guys. It is a massive, not just like Copaganda, propaganda, it has resulted in massive misunderstanding of how the system is actually operating.
You'd be forgiven for thinking someone was guilty by the mere fact that they're in court after watching your 500th hour of Law & Order, and the next 500 would only confirm that assumption. As Shitterman writes, quote, "Ultimately, when a suspect in the show enters a plea, goes to trial, and receives a conviction, or is wrongly acquitted, the implication is always that the defendant was factually, not just legally, guilty." According to the arc of a Law & Order episode, this view would be logical. The person on trial must be guilty, because if he or she were not, the ADA would not have brought the defendant to trial. And if you know that you must have the right guy, anything that gets in the way of a conviction, like say, those pesky little civil rights, are at best annoying technicalities, and at worst, threats to be neutralized. Nowhere is this more apparent than in the way the show portrays one of the most recognizable rights you have. The one read in every episode, known by every American.
You have the right to remain silent.
Anything you say can be used against you in a court of law.
You have the right to an attorney.
If you cannot afford one will be appointed to you. You understand all that?
In 1966, the landmark Supreme Court case Miranda v. Arizona was decided. In a 5-4 decision, the liberals of the court held that in order for your Fifth Amendment right against self-incrimination to actually function in our society, law enforcement officials must inform a suspect in custody of those rights. The idea is that if you don't know what your rights are, do they really exist in practice? This court case changed the landscape of American policing forever, and is probably one of the most famous parts of our criminal justice system. Miranda warnings advise an arrestee of two things: their right to silence and their right to legal counsel. Any statements a suspect makes without being notified of these rights is inadmissible in a court of law.
So in very basic terms, say you're detained, you're being interrogated by police, you confess to a crime. You say, yeah, I did it. If the police didn't tell you that you had the right to an attorney, that you had the right to remain silent, right? That you could decline to answer any of those questions, the prosecutor cannot present your confession against you at trial and say, look, he said he did it. Here's this statement.
And once a defendant in custody asks to speak with a lawyer or invokes their right to silence, all interrogation must cease until a lawyer is present. This is an aspect of our criminal justice system so popular, in fact, that countries across the globe have adopted it.
Everybody knows sort of generally what Miranda means, not just in the US. Like, Miranda is an important case in terms of what people internationally think about the United States Constitution, right? Like, Miranda is this thing that everybody knows American cops have to abide by.
We did something good, guys. We did it. It was us. America, spreading its values. USA, USA. But not everybody loves Miranda rights, like the prosecutors on Law and Order.
Wanted to talk to you alone.
Well, a guy named Miranda ruined that for both of us.
While Miranda rights are read to suspects all the time on the show, the next scene usually includes a suspect explicitly waiving those rights.
You're still my client until you legally waive that right.
Bye-bye, butthead. Bye-bye. Bye-bye, butthead. Bye-bye.
I'll get the form. We're back in. She waived Miranda.
Or talking to the police in an interrogation with no lawyer present whatsoever.
If somebody does waive their Miranda right, they say, yes, I understand that I have the right to remain silent. I have the right to an attorney. I'm going to waive those rights and I'm going to talk to you, police. I'm going to answer your questions, right? Miranda, the case, says that that waiver has to be knowing and intelligent. The police have to show that the person actually understands what those rights mean.
This portrayal alone of people not being silent but freely talking to the police without a lawyer present is something that has clearly warped our cultural viewpoint of the police.
Do you think that the way that the shows present, like, talking to the police as giving you like a plea deal is a reason that people do talk to the police without like a lawyer present?
Yes, 100%. Yes, yes. I think one of the main reasons why you see, and it, when you realize it, how many shows in real life, even just not even just shows like the fictional ones, but even when you just watch their regular Copaganda real life, talking to police because the police said to them that they could in some way make this easier or harder. Meanwhile, police don't even know the law. 9 times out of 10, the shit that they told you they was arresting you for isn't even going to be what you get charged with. They have no fucking idea of the law or how this case goes.
They're trying to get you into the system so they can get you to say something that they can then turn into a different charge, right?
Yes. But they're allowed to lie. That's one thing the Supreme Court lets them fucking do. So the police officers are allowed to lie. So what they will do is they tell people, oh, if you cooperate, I'll get you this. I can make this easier for you.
Nicole Bell, you're under arrest for murder.
What? You just said that.
Yeah, I lied.
No.
If you don't know this by now, you should never talk to the police for any reason. You shouldn't talk to them. I don't care if you're on a Tinder date and find out that the hottie sitting across the table from you is a cop. You get the fuck up and you leave. Do not talk to the police. I cannot say this forcefully enough. They are always fishing for something to charge you with. Do not talk to the police. You don't even have to take my word for it. Here's a law professor saying it.
The Congressional Research Service can no longer even count the current number of federal crimes. That's right, even the federal government has lost count. You people, you've got 10,000 different ways of convicting us. Good for you, but you know, with the bitter comes to the sweet, with the good comes to the bad. That's 10,000 different ways my client might unknowingly implicate himself in some sort of a criminal transaction.
Here's a cop saying the exact same thing.
That's a fact, but everybody does something that they can get in trouble for. I can follow as a police officer when I was in uniform. I could follow a car however long I needed to, and eventually they're going to do something illegal.
And here's Supreme Court Justice Robert Jackson, who prosecuted the Nazis at Nuremberg, saying, quote, "Any lawyer worth his salt will tell the suspect in no uncertain terms to make no statements to the police under any circumstances." But why? Well, contrary to what you see in Law & Order, the police do not have the ability to offer a plea deal to you. They are also legally allowed to lie to you. And you can be damn sure that anything you say not only can be used against you in a court of law, but will be used against you in a court of law.
Under the rules of evidence, specifically Rule 801D2A, if you want to look it up, everything you tell the police, as the saying goes, can and will be used against you, but it cannot be used for you. From time to time, I've known attorneys who tried to call to the stand a police officer and say, "Officer, would you tell the jury what my client told you because what my client told him is actually good for my case?" If you tried that at trial, the prosecutor will object that it's hearsay, and the judge will agree. The police will not be allowed, at your request, to tell the jury what your client told him, no matter how good it may be for your case. It cannot help.
You keep your pretty little mouth shut! And Law & Order's normalization of talking to the police cannot be overstated in its importance, especially because of the reasons behind the Miranda decision in the first place.
Pre-Miranda, the normal practice of police across the country would be you arrest somebody you suspect of committing a crime, you throw them in a tiny room for hours, you don't give them water, you don't give them food, you don't give them the ability to talk to anybody, to make a phone call, right? There were police training manuals across departments, again, across the country that told police how to use psychological trauma and psychological warfare against a person to extract a confession out of them, right? Actual evidence be damned. Police were being trained on how to get somebody to say they had done something.
What's wild about Law & Order is how the show talks out both sides of its mouth about Miranda, like in this particularly weird and egregious example from season 6, where new evidence brings up a cold case from 1965, a year before Miranda. There are a few issues with that case, including a massive conflict of interest on the part of the defense attorney for Mr. Munoz.
His loyalties were split, Your Honor, between his former client, a popular young woman, and the man accused of brutally attacking her, a nuisance client that the court dumped into his lap. No one could expect him to be impartial.
But for our purposes right here, the defendant gave a confession. But as McCoy notes, coerced confessions were pretty routine back in the day.
Munoz confessed. After how many rounds with New York's finest?
All the defendant is asking for now, after 30 years in prison, is to not be denied parole.
He's been denied parole 3 times. His next at-bat's in 2 weeks. Support his application. We'll drop this motion.
Which, in my humble opinion, is, not that much for someone who was beaten into confessing a murder given inadequate counsel and only has a 6th grade education.
He has a grade 6 education. He will do anything his lawyer tells him to.
Oh, and by the way, here's how the cops arrested him back in the day.
Hispanic male driving a beige car. How many people fit that very unique profile?
I wouldn't know, but a witness picked Munoz out of a lineup.
A lineup consisting of my client and 5 Irish cops, isn't that right?
I didn't ask their ethnic origins.
So we've got a case here where this guy has already served 30 years for a pretty sketchy conviction, and his confession would have been deemed inadmissible just a year later when the Supreme Court decided Miranda. It is well within McCoy's power to drop this case at any point, or to even just, not fight him getting out on parole, which he pretends is all about the victim's family.
As long as Miss Costello agrees.
But he spends time and resources going after this guy. He and his prosecutor buddies complain about the fact that they got some woke judge who wants to apply Miranda retroactively.
We had to pull the one judge who reads the canons with a microscope.
This would never happen, by the way. They ask the judge to deny bail.
Your Honor, we ask bail be denied. Mr. Munoz confessed to the crime.
He's already served 30 years. He's earned a little R&R.
And then the ending heavily implies that things were better back in the day, before those pesky Miranda rights.
30 years ago, no judge would have let Miss Terry Marks get away with that kind of muckrake.
30 years ago, you had a confession. Bad evidence, bad memories, bad rulings.
Oh no, someone's constitutional rights were protected. How can we expect prosecutors to work under these conditions? I don't know where that voice came from. I am sorry. There's this episode of SVU where a suspect asks for a lawyer and isn't provided with one.
I want a lawyer. Jason, I'm willing to hear your side of the story, but you bring a lawyer into the situation? It's just gonna screw it all up. They don't help it. They just make it worse.
He's then tricked into voluntarily staying and confesses.
The confession gets thrown out by the judge, even though the suspect was not under arrest when he made this confession. We'll get more into that in a second. And the DA butts heads with psychopath Stabler over him messing up her case.
I specifically cautioned you about the custodial issue.
No. You said that he was to be free to go at any time. Now, my detective persuaded him otherwise. He did a hell of a job getting that confession.
Whose side are you on?
Because I stayed in that room and pushed him to the edge, and you lost him on a technicality.
All right, that's enough, both of you.
This language, referring to Miranda rights as technicalities, all while openly endorsing coercive confessions, is all over the franchise.
Wrong should not win by technicalities. You know that yourself.
It gets old watching humps walk away from prison bids on technicalities.
Can you assure me the defendant wasn't hurt and I'm not going to get my ass kicked in court on a technicality?
Save it. You're a murderer walking on a technicality.
If he coerced the first confession, it is still fruit of the poisonous tree.
What fruit? Was it some stupid technicality?
Even when the show isn't this psychotic, it still finds a way to distort the way Miranda works. In the very first episode of the rebooted 21st season, Executive Assistant District Attorney Nolan Price wants to throw out a confession made by a woman who hadn't been Mirandized.
But to be clear, in this case, it wasn't one little lie or embellishment. Cosgrove spun the suspect upside down. He practically promised her immunity.
Legally speaking, this is an idiotic argument. You don't get Mirandized until after you've been arrested. When she made that statement, she wasn't even under arrest. She was just a fucking idiot talking to the police voluntarily without a lawyer present.
So you killed him?
He needed to be stopped. He would have kept raping people. So yes, I shot him.
So here we have a prosecutor bending over backwards to throw out a perfectly legally acceptable confession because he's just a nice guy. You know, I bet he rants on Reddit about the friend zone, about how he's been friend zoned by Hannibal Lecter.
I know what kind of crazy I am, and this isn't that kind of crazy.
And, well, that's just not how the courts or prosecutors actually view Miranda. In the span of the first 2 years of Nixon's presidency, he was able to appoint 4 justices to the court, lurching it far to the right, not unlike another Law and Order candidate.
Again, it's like poetry, so if they rhyme.
Although Nixon was much more successful in stealing his election. Ever since that moment, the cops of the Supreme Court have whittled away at Miranda, never overturning the incredibly popular ruling outright, but making sure it's as toothless as possible.
You still have Miranda rights, like in theory. The Supreme Court hasn't ever explicitly overturned the decision, Miranda v. Arizona, right? But there have been this series of cases specifically about Miranda that weaken Miranda so considerably and really make it so that, you know, Miranda is this really powerful protection of constitutional rights that the US says is so special, but it's only in theory and not really in practice.
In 1971, the court ruled in Harris v. New York that while illegally obtained confessions were inadmissible in a court as evidence of a defendant's guilt, you could still bring them up and use them to discredit their general testimony. I'm sure any non-lawyer on the jury is able to make that distinction no problem. In 1980, the court heard a case called Rhode Island v. Innis, where Mr. Innis was arrested for an armed robbery with a shotgun, Mirandized, and then immediately asked for a lawyer. Good job, Mr. Innis. Story should end there, but of course it does not. In the squad car on the way back to the station, the cops in the front seat started talking about how the area had, quote, a lot of handicapped children running around, and how it'd be awful if one of them found that shotgun and hurt themselves. Mr. Innis, worried for the children, told the cops where the shotgun was, and he was punished for it. The court ruled that although Innis had asked for a lawyer and shouldn't have been interrogated without one, the backseat of a squad car doesn't really count as an interrogation, since the cops weren't talking to him or trying to convince him into confessing, just randomly chatting aloud to each other about the deaths of handicapped kids. You know, as cops are wont to do. As Justice Potter Stewart explained it in the majority opinion, quote, respondent was not subjected to the functional equivalent of questioning, since it cannot be said that the officers should have known that their conversation was reasonably likely to elicit an incriminating response. There is nothing in the record to suggest that the officers were aware that respondent was peculiarly susceptible to an appeal to his conscience concerning the safety of handicapped children. Who could have possibly known that he'd have such a soft spot for handicapped kids that the police could leverage against him? I, Potter Stewart, have never once thought about a handicapped child. Wouldn't have worked on me. Checkmate, liberals. In 1984, Miranda was further eroded in a case called New York v. Quarles, which created the public safety exemption, which basically means that you can question someone without Mirandizing them, so long as it's in the interest of public safety. Now, you might be thinking that this gives the police a lot of wiggle room. But don't worry, noted segregationist Chief Justice William Rehnquist wrote in the majority opinion that, quote, "We think police officers can and will distinguish almost instinctively between questions necessary to secure their own safety or the safety of the public and questions designed solely to elicit testimonial evidence." I wish I had like a witty quip for that one, but that's just fucking stupid. The most modern versions of the court are even more hostile to Miranda. In 2000, the slimy pile of fish paste wrapped in wrinkly leather that's known as Antonin Scalia laid the groundwork for this modern attack, writing, "I'm not convinced by petitioner's argument that Miranda should be preserved because the decision occupies a special place in the public's consciousness. Look, there's this thing that everybody likes and makes sure that people know their rights, but I, Antonin Scalia, hate that because I'm a petty, evil little man."
Yeah, no, I mean, what I have to say about Scalia is I'm grateful that he's dead. It's good that he's dead. He was a bad justice. He was a bad judge. He was bad on the law. He wasn't as smart as people say that he is. He was ridiculous and he was harmful.
In 2011, in a case called Burgess v. Tompkins, the court ruled that you can't invoke your right to silence by being silent.
It's like completely illogical, right? It means you have to speak out loud in order to protect your right to remain silent, right?
And can you say, you know, I want to remain silent? Would that work?
That is a really, really good question, because what the fight becomes, that fight in the courtroom about whether this person's Miranda rights were protected or not, right? What that fight becomes about is whether somebody invoked their right to remain silent clearly enough.
To get an idea for just how fucking ridiculous this ruling is, here's a judge going so far as to rule that saying, quote, "I know that I didn't do it, so why don't you just give me a lawyer, dog? Because this is not what's up." Yeah, the court ruled that that's too ambiguous because the suspect could have been asking for a canine lawyer.
These courts are like creating these legal magic words that somebody has to know ahead of time in order to invoke their constitutional rights. And so, yeah, it makes it incredibly difficult to invoke your own constitutional rights. It puts the burden on you to say, I have this constitutional right that I want to exercise. And it makes it completely inaccessible, completely unknowable what it is to the common person, what it is you're supposed to say to make sure you're exercising your constitutional right in the correct way that a court will recognize and agree with.
Just last term, the court ruled in Vega v. Tico that even if and when officers fail to read Miranda warnings, you can't sue them for a civil rights violation anyway. And this is the whole game that the Supreme Court has been playing for nearly 6 decades, trying to whittle away Miranda rights until they're utterly meaningless. These guys are cops, okay? These guys are cops. That's the point of the video. They're cops. Cops all the way down. And I think that the way Law & Order portrays Miranda rights has gone a long way towards priming the public to be amenable to its repeal. It portrays this incredibly popular and important civil rights protection as, at best, a frivolous technicality. But in the world of Law & Order, where everyone is guilty until proven innocent, it's often way darker than that. Law & Order normalizes the perspective that Miranda rights, which again are simply the police honoring your 5th and 6th Amendment constitutional rights, are loopholes from which evil criminals can escape to kill again. In 2022, when the Dobbs decision came down overturning Roe v. Wade, a lot of people started to think differently about the Supreme Court. I remember getting a text from my dad saying, "These guys are really out of control. Where is this coming from?" I'm sure he won't watch this video, so it doesn't matter. Likewise, you might have been surprised to hear just how much the Supreme Court has deferred to the police throughout the jurisprudence around Miranda. After all, this is a body famous for, as Chief Justice John Roberts claims,
"It's my job to call balls and strikes, and not to pitch or bat."
And just like in baseball, it's time for robot umps. Because the court has always capitulated to the police. Even our boy Earl Warren. Back in 1968, the case Terry v. Ohio decided that the police don't need probable cause to search your person, creating the concept of reasonable suspicion out of thin air.
Today, these are known as Terry stops, or as stop and frisk, where the police can search you on the flimsiest of evidence and try to find a reason to arrest you, which is definitely not problematic at all. Definitely has not been leveraged against a certain demographic population in the United States. We'll get more into that and the Fourth Amendment in video 2. It's just a teaser. The court has even upheld our bail system, ruling in 1984's United States v. Salerno that even though the Eighth Amendment explicitly states that excessive bail shall not be required, courts can simply impose detention without bail at all, which is really not any different. As Thurgood Marshall wrote in his dissenting opinion, if excessive bail is imposed, the defendant stays in jail. The same result is achieved if bail is denied altogether. Whether the magistrate sets bail at $1 billion or refuses to set bail at all, the consequences are indistinguishable. So cool that we replaced that guy with Clarence Thomas. Maybe we can hold his wife in prison without bail for her role in January 6th. All the while, the court has removed possible remedies, creating doctrines of immunity that shield both the police who arrest you and the prosecutors who try you. Well, they don't really try you so much as they just threaten you with years of contact with the system until you give up and plead guilty.
We talk on the podcast all the time about rights without remedies. You can say that you have a right. A court can say that you have a right. Sam Alito can say that you have a constitutional right.
I don't think he will, but...
right, it's unlikely, but he can. But if you don't have a remedy, a legal remedy for making yourself whole somehow after a right is violated, then what does the right mean?
That's because the process is part of the punishment. How much the system sucks? Yeah. That's the point.
Most cases in the criminal system will never end in conviction, end in trial, or end in incarceration. They don't have the evidence, the means to do that. So what they do is, by having these long processes where you have a case and all the collateral consequences that come from having to appear in court, from having an open case, that's how they get you. That's why police make arrests on cases they know will get thrown out, or they know it's bullshit, or they want to retaliate towards you. You know how many people I've represented where they have no charge? They're charged with disorderly conduct, which is an infraction. It's not a crime in the first place. And it's they mouthed off to the police. The police was irritated with them, and they brought them in and arrested them knowing that this can't go anywhere. But the way that they will stress out and make a person's life hard in the interim, that's where the power is in.
This worldview has warped our legal system into what associate law professor Isa Kohler-Hausman calls the managerial model of criminal court. This system is less interested in identifying and punishing bad conduct the way we generally think the court works. Instead, the purpose of the managerial model, as Kohler-Hausman describes it, is to sort and regulate people over time. The criminal process is deployed to figure out the rule-abiding propensities of people and calibrate formal regulation accordingly. In other words, it's all about finding the people who are totally going to be criminals at some point and making sure that we keep them in constant contact with the system until we can find a reason to throw them in prison the second it's even remotely legally allowed.
It's a slap in the wrist misdemeanor. We only have him in custody on Fletcher's bad arrest.
Well, we all know it's just a matter of time before he rapes again.
On the one hand, we have innocent until proven guilty, but on the other hand, sometimes you just know a bad boy when you see one. This can help explain why, in New York City, where law and order takes place, even as crime has fallen over the past few decades and felony arrests have fallen with them, there are more misdemeanor arrests than ever before, ballooning from about 65,000 per year in 1980 to 250,000 per year in 2011.
There's a thing in New York City called ACDs, an adjournment and contemplation of dismissal. So they know that they have to dismiss this bullshit, stupid case eventually. So what they will say is they won't just fucking dismiss it like a reasonable person. They'll say they'll agree to an adjournment and contemplation of dismissal, which means they will keep this case open for like 6 months or a year with the understanding that they'll dismiss it and seal it then.
Approximately 30% of all misdemeanor cases in New York City result in adjournment in contemplation of dismissal like this, where prosecutors agree to dismiss a case, but basically keep it on the record for 6 months to a year in the meantime, without a guilty plea, or a conviction, or anything.
You know, and you're like, this thing you did not do, this stupid case that is definitely going to be dismissed. But imagine trying to convince the average person. I swear to God, the court agreed that they're going to dismiss it. They said I made it as a stupid case. They're going to dismiss it in a year. They're like,
Sure. Simply being in contact with the system like this, regardless of how your case turns out, has tons of adverse consequences. Applying for housing or a new job is incredibly more difficult with a case on the docket. On top of that, a study by Kevin Morris and Jonathan Ben Menachem in 2022 found that, quote, traffic stops materially decrease participation for Black and non-Black residents alike in elections. Although they found that the stops are just such the norm for Black people that its effects are a little bit lower. That normalized contact has other terrible effects on health, however, both mentally and physically. A 2019 study published in the National Library of Medicine found increased PTSD presence in populations with high lifetime police stops, and a 2021 meta-analysis published in JAMA Pediatrics found, quote, an association between police exposure and adverse mental health, sexual risk behaviors, and substance use for Black youth. In fact, for as much as we think of the police when we think of mass incarceration, law professor and researcher John Pfaff found in 2013 that if we're looking for the guy who did this, we need only look at prosecutors, writing, quote, with regards to who, the answer appears to be prosecutors, at least since the crime drop began in the early 1990s. Hey, that's right when Law and Order started. Crime has been falling. Arrests per crime have been relatively flat, with a slight rise in the 2000s due to drug arrests. Admissions per felony filing have not budged, and time served has been relatively stable, but felony filings per arrest have soared during the 1990s and 2000s. Prosecutor associations across the country have banded together to fight police reforms as well. As Udi Offer of the ACLU told The Nation, quote, in state after state, we've seen DA associations hold back reforms that are supported by Democrats and Republicans alike, but the legal system still remains largely left out of police reform conversations.
America loves to do a thing where they discard part in order to preserve the whole, right? To me, it's the way, if you look at it in terms of the private prison narrative, like America will feed you the criticism of the private prison. So then otherwise you're like, prisons are good. I still maintain prisons.
Yes.
Private prisons. The police problem became too big to save, right? So like police are the arm of the state they're willing to sacrifice. Like, okay. It's fuck the police, but they leave all the attention focused there and it never goes past there.
The way that the Supreme Court has created all these rules that in effect, the result is that we just rubber stamp convictions, right? Where we're supposed to be building a fair and just and equal, criminal legal system. And the rules that they come up with, which is that, like, for example, the prosecutor should have turned over that evidence that somebody else did it, but would it really have changed the jury's mind? I'm not sure.
This kind of deference to prosecutors is all over our legal system. One of the reasons why the Supreme Court sucks on criminal issues is because none of them have ever been involved. They've all gone to either Harvard or Yale and been buried in legal theory land since puberty. In our current court, only 3 justices have practiced criminal law at all: Alito, Sotomayor, and Jackson. Alito and Sotomayor were both prosecutors, while Ketanji Brown Jackson is the first public defender to ever serve on the court. And even getting just that one was way more difficult than it needed to be. In 2016, federal appeals court judge Jane Kelly, a former public defender, ended up on Barack Obama's shortlist. It should have been a moment for celebration. I mean, we might have had someone who wasn't in the bag for the cops. Plus, Scalia was finally dead. Win-win! But conservative activists spent $250,000 on attack ads smearing her record. As Jay Willis neatly summed it up for the appeal, in the United States, only one side of the criminal legal system gets treated as working in the public interest. And I think that this is the same kind of ethos that Dick Wolf has sold to the American people for over 30 years through Law and Order, using his platform to support police, prosecutors, and an unjust system. Just this year in 2023, Law and Order argued vehemently against bail reform, despite the fact that these are people who have not been found guilty of any crime. The only crime that they've committed is being arrested.
Wasn't too long ago, we were locking up people for not being able to scrape together $100 worth of bail. He was sitting in Rikers for months, some years, while their dumbass misdemeanor cases would just drag on and on.
That may be true, but I'm not sure the cure is any better than the disease.
I hear you, Frank. We overcorrected.
Ah, yes. Being not in jail before being found guilty of any crime is definitely worse or just as bad as being held in Rikers for years just because you look guilty. Because in Law and Order, the only people who are in a position to pay bail are dangerous ones who will definitely do crime as soon as they get out. This flies in the face of the entire concept of innocent until proven guilty that most of us believe in. Although if you are one of those in a police population, you already knew this.
So here's the fucked up thing about the criminal system, right? Is the criminal system preys on particular populations. So even if the people you're representing, it may be their first themselves, their first incident with the criminal system, it is not their first knowledge of the criminal system, right? Like they have a community, they come from a community in which people are policed and treated this way. You rarely, as a public defender, you rarely ever represent white people, because that's just not who's in the system. But when you do, representing white people is the most frustrating thing in the world because they cannot fucking believe this is happening. Like, because it is an outraging thing when you realize it in application, especially if you're told all the time that innocent until proven guilty means something, and you believe that, and you watch it function like that in the white world, right? So if you watch like Copaganda, you watch the news, you watch anything that ever happens, anytime any white people on the news, any white powerful people get accused of something, what happens? They're not arrested.
Innocent until proven guilty. Yep.
Yes, they say they didn't do it, and then the police are like, well, they didn't do it, and we have to do an investigation like before we could ever bring charges, and that's just not how the system works in application.
And this is the crux of the issue. In our segregated country, where the violence enacted on the poor and people of color is largely invisible to the majority of the country, a franchise like Law & Order is shaping a great deal of understanding of the legal system. And it not only presents an intentionally distorted view of justice, but actively tries to undermine the civil liberties that our country was built on, in line with the broader American political conservative movement. I'm already hard at work on the next part of this massive episode on Law & Order. I already had a bunch of it written actually, but it was really overwhelming to do in one video. In the second episode, we'll talk about other rights that are misunderstood, like the Fourth Amendment and what's called Brady material. But I wanted to start here with plea deals and Miranda because I think it's a really good case study for looking at structural problems with courts as cops. If you want to see that second part of the video, the second it's done, you can check it out on Nebula. Nebula is a streaming service that is collectively owned by us creators. There, you can see longer uncut videos that would be demonetized on YouTube because of a small 20-second clip that got copyright claimed. Like this video, I had to whittle down a few of my examples just to get the YouTube algorithm gods to smile kindly upon me. Nebula also allows creators to cover topics that we never could on YouTube, like Broey Deschanel's videos on sex scenes in TV and movies, and Leo Vader talking about how Gordon Ramsay shows his pasty white bare naked white ass in every episode of Hotel Hell. Nebula is home to all sorts of original content as well, videos you won't be able to find anywhere else from some of the best creators in the game. Another cool thing about Nebula is that if you sign up for it using my link, a portion of your monthly subscription goes directly to me, which is a really nice way to help the channel while also getting access to way more content. Seriously, it's really easy to lose yourself browsing through what is essentially Netflix for video essays. Nebula is only a little over $2.50 a month if you sign up using the link below, which, in this economy, very cheap. So, to recap, Nebula gets you access to the next episode of Copaganda first, the videos are longer and uncut, you get access to exclusive content, and a portion of your low price of $2.50 a month goes directly to me, your favorite creator. Clearly. I mean, you're still watching this after all. Sounds like you better click that link. Click it! Get to clicking! And if you want to support this channel in another way, you can go over to patreon.com/skipintro. There's a bunch of channel-specific goodies there, like my full interviews with Olay and Rhiannon, monthly mailbags, and TV reviews. There's also bonus videos from my second channel, Little Skippies. All in all, we're talking about like 5 to 6 pieces of bonus content a month, and Patreon is a huge reason why I'm able to invest as much time researching as I do into these projects without putting out a half-baked video every other week. Patreon. It's cool, and you get to be one of these scrolling names, which really is the highest honor there is. Anyways, talk at you again next time.